disclosed Lord Pontefract's proposals and his own to Mr. Storrow and Mr. Andrade, that Mr. Olney consulted with them, including in his own home, prior to writing to Lord Pontefract, and that Mr. Olney's proposals were consistent with those previously submitted to him by Mr. Storrow. The correspondence leaves no doubt that both Mr. Storrow and Mr. Andrade were privy to the so-called confidential notes and to the agreements on prescription and the 1850 agreement that were reached therein. Professor Palchetti referred you to the transcript of the arbitration hearings more than a year later, in which former President Harrison, Venezuela's lead counsel, seems to have been surprised by the existence of these notes. If he was unaware of them, it's Venezuela's fault. Its two representatives in Washington plainly knew of the notes and their contents at the time they were exchanged. Mr. Harrison himself speculated that Mr. Storrow would have known of them. He further speculated that perhaps Mr. Storrow decided not to share them with his client. But that is speculation, not evidence, and it is wrong, because Mr. Andrade, Venezuela's minister in Washington, was made aware of them at the same time as Mr. Storrow. Professor Palchetti seems to have contempt for Mr. Storrow. Why so? What did Mr. Storrow ever do to him? Obviously nothing. But the animus toward him fits well with Professor Palchetti's imaginative conspiracy theory about U.S. malevolence. According to Professor Palchetti, Mr. Storrow was a double agent, the Kim Philby of his day, who secretly served U.S. interests contrary to Venezuela's. There is no evidence of this. It's another Venezuelan myth, another concoction. Mr. Storrow deserves better. He was one of the most renowned American lawyers of his day. He earned Venezuela's trust by serving as its counsel before President Cleveland's Boundary Commission, leading to their invitation to him to represent their interests in the negotiation of the arbitration agreement with Great Britain. Foreign Minister Rojas initially expressed some hesitation about hiring him, but there is no record of disappointment in his efforts or accomplishments on Venezuela's behalf, or any doubt about his loyalty. Upon Mr. Storrow's sudden and untimely death, he was eulogized by the President of Venezuela. The fact that Mr. Storrow enjoyed Secretary Olney's confidence and had regular access to him, having attended law school together, was a benefit to Venezuela, not a detriment. And this is reflected in the contemporaneous correspondence between them, which you have seen, which resulted in Mr. Olney successfully negotiating for the outcomes proposed by Mr. Storrow and Mr. Andrade on the two issues Venezuela says it regarded as the most critical: the length of the prescription period and the preservation of the 1850 agreement. Mr. President, what this unchallenged contemporaneous evidence shows about the events leading to the negotiation of the 1897 agreement and the actual negotiation of it is that there is no truth in the poor Venezuela narrative. A fledgling republic, unjustly robbed of its territory by the superpowers of the day, the nefarious British and treacherous Americans. The narrative that Venezuela and its council are trying so hard to sell to you. In Texas, they would simply say, "That dog don't hunt." Mr. President, it is not often in my career that I have stood up and defended the lawfulness of U.S. foreign policy. But we are talking about the 1890s, My country was not then claiming Greenland or Canada as the 51st state. I turn now to 1966 and the Geneva Agreement, in which the United States, fortunately, played no part. Venezuela claims that the Geneva Agreement set aside and replaced the 1899 arbitral award, so that the validity of the award is not at issue in this case and therefore is not for the court to rule on. They referred to this as a novation. In fact, it is a novelty. Venezuela made the argument for the first time in its rejoinder, filed last August. Apparently, it took them 59 years after signing the agreement and 7 years after the initiation of this case to come up with this interpretation. But as the saying goes, there is no one as zealous as a recent convert. And all of Venezuela's counsel, all 8 of them who spoke on Wednesday, expressly made or endorsed this argument. It seemed to us, from their rote-like and repetitive incantation of fealty, that this was the price they had to pay for admission to the podium. We say this argument is as off base as it is novel. We base our response to it on the text of the 1966 agreement itself. My friend, my very good friend, Professor Zimmerman, gave you Venezuela's interpretation of the text. But he was not nearly as thorough or as accurate as he was in his indispensable treatise on the statute of the court. Astonishingly, in his article-by-article review of the agreement, he completely skipped over Article 5. Given his customary meticulousness, this was surely not an oversight. So why did he decide to avoid discussion or even mention of Article 5? Let's look at the text. Paragraph 1 states that nothing contained in this agreement shall be interpreted as a renunciation or diminution by the United Kingdom, British Guyana, or Venezuela of any basis of claim to territorial sovereignty in the territories of Venezuela or British Guyana, or of any previously asserted rights or claims to such territorial sovereignty. Paragraph 2 states, no acts or activities taking place while this agreement is in force shall constitute a basis for asserting, supporting, or denying a claim to territorial sovereignty in the territories of Venezuela or British Guyana, or create any rights of sovereignty in those territories, except insofar as such acts or activities result from any agreement reached by the Mixed Commission and accepted in writing by the government of Guyana and the government of Venezuela. Well, I think we found the answers to our question. Professor Zimmerman told us that the Geneva Agreement has no savings clause. He contrasted it with the Polish Danzig Agreement, where such a clause exists. On this basis, he argued that all rights and obligations claimed by the parties under prior legal instruments, including the 1899 arbitral award, were set aside and replaced by new rights and obligations under this 1966 agreement. But that is directly contradicted by paragraph 1, which bears all the hallmarks of a savings clause. It is undeniable from the text that this preserves all assertions of rights and obligations under the 1899 arbitral award. Professor Zimmerman also told us that the conduct of the parties after the signing of the agreement, in particular their participation in negotiations via the Mixed Commission, demonstrates their understanding that the rights and obligations under the 1899 award had been set aside and replaced. But that is contradicted by paragraph 2, which expressly provides that no future conduct pursuant to the agreement can be understood to constitute a waiver of pre-existing rights unless the waiver is express and pursuant to an agreement between the parties. There is no evidence of any express waiver or any such agreement. Beyond Professor Zimmerman's remarkable excision of Article 5 from the agreement, there is his tortuous reading of Article 1. The reference in the text to controversy in that article, he tells us, can only refer to the controversy over title to territory, rather than any controversy over the validity of the 1899 arbitral award, because, he tells us, the same word, controversy, was used in the 1897 treaty, 2 years before the award was issued. It sounds like a sophisticated analysis, but it's just a piece of sophistry, because it ignores the actual text of Article 1, part of which, in my friend's reading, suffers the same ignominious excision from the agreement as the whole of Article 5. It's on your screens now. The controversy between Venezuela and the United Kingdom, which has arisen as a result of the Venezuelan contention that the arbitral award of 1899 about the frontier between British Guyana and Venezuela is null and void. The controversy identified in Article 1 is plainly not the same controversy as the one mentioned in the 1897 treaty. It is the, quote, controversy that has arisen as a result of Venezuela's contention that the arbitral award of 1899 is null and void. This text, especially when read in light of the text of Article 5, thoroughly defeats Venezuela's novation argument. If there is a controversy over Venezuela's contention that the award is null and void, as Article 1 says, it can only mean that the other parties to the agreement, namely Great Britain and British Guyana, ultimately Guyana, disagree with Venezuela's contention. That is, they do not agree that the award is null and void. To the contrary, they maintain, as they always have, that it is valid. So if they maintain that the award is valid and they claim rights under it, as they do, and Article 5 expressly preserves all rights and obligations claimed under instruments that predate the 1966 agreement, how can it possibly be maintained that Great Britain and British Guyana, later Guyana, agreed by signing this agreement to abandon their rights and claims under the 1899 award? The answer is obvious. Their claim is frivolous. Venezuela's argument that the 1966 agreement somehow set aside and replaced the 1899 award cannot be reconciled with the text of that agreement, especially if one reads the text that Professor Zimmerman would have you ignore. And I can cite unimpeachable authority for this, Guyana's reading of the Geneva Agreement, and the rejection of Venezuela's, rendered by the tribunal, and the implications of this question for their frontier. Thus, Article 1 of the Geneva Agreement defines the mandate of the Mixed Commission as seeking satisfactory solutions for the practical settlement of, quote, the controversy between Venezuela and the United Kingdom, which has arisen as a result of the Venezuelan contention that the arbitral award of 1899 about the frontier between British Guyana and Venezuela is null and void. That contention by Venezuela was consistently opposed by the United Kingdom in the period from 1962 until the adoption of the Geneva Agreement on 17 February 1966, and subsequently by Guyana after it became a party to the Geneva Agreement upon its independence in accordance with Article 8 thereof. In regard to Article 5, the Court determined in paragraph 65, by referring to the preservation of their respective rights and claims to such territorial sovereignty, the parties appear to have placed particular emphasis on the fact that the controversy The controversy referred to in the Geneva Agreement primarily relates to the dispute which has arisen as a result of Venezuela's contention that the 1899 award is null and void, and its implications for the boundary line between Guyana and Venezuela. In sum, the text of the Geneva Agreement, as understood and explained by the Court, cannot be reconciled with Venezuela's novel reinterpretation of the agreement as a novation dispensing with the 1899 arbitral award. Professor Dargent will have more to say about this subject and the effects of the 2020 judgment. Before concluding, Mr. President, I want to respond to Venezuela's presentation of itself as the South American continent's foremost crusader against colonialism and promoter of Guyana's decolonization. This is another Venezuelan myth that cannot be reconciled with the facts. The historical record shows that Venezuela was an obstacle to Guyana's independence, not a facilitator. It strains to link its belated assertion of the invalidity of the 1899 arbitral award to the iconic resolution on decolonization adopted by the General Assembly in 1960. There is no such link. Venezuela has presented no evidence of one. A more historically accurate explanation of the timing of Venezuela's denunciation of the arbitral award in 1962 is that British Guyana was then entering the final stage of its own decolonization process, and Venezuela sensed an opportunity to exploit the new republic's weakness after the lowering of the Union Jack and the departure of British troops by resurrecting its bogus claim to the vast majority of Guyana's sovereign territory. Here is what Venezuela itself told the Court in its memorandum on jurisdiction submitted on 28 November 2019. The beginning, well, I had hoped to show it to you, but I will read it to you. Quote, "The beginning of the process of decolonization of British Guyana within the framework of the United Nations prompted the Venezuelan government to formalize a claim in this regard. To prevent the independence of the British colony, supported by Venezuela, from becoming an obstacle for its claim, based on historical justice backed by the many causes of nullity of the aforementioned award." Venezuela's interests were not benign. They were self-serving and predatory. They were to acquire the Essequibo at a time when newly born Guyana would be powerless to maintain it.